Suggested answers to the 2018 bar examinations in labor law. Question. Narciso filed a complaint against Norte University for the payment of retirement benefits after having been a part-time professional lecturer in the same school since 1974. Narciso taught for 2 semesters in the summer term for the school year 1974 to 1975, took a leave of absence from 1975 to 1977, and resumed teaching until 2003. Since then, his contract has been renewed at the start of every semester and summer, until November 2005 when he was told that he could no longer teach because he was already 75 years old. Norte University also denied Narciso's claim for retirement benefits, stating that only full-time permanent faculty who have served for at least 5 years immediately preceding the termination of their employment can avail themselves of post-employment benefits. As part-time faculty member, Narciso did not acquire permanent employment status under the Manual of Regulations of Private Schools in relation to the Labor Code, regardless of his length of service. Is Narciso entitled to retirement benefits? Suggested answer. As a part-time employee with fixed-term employment, Narciso is entitled to retirement benefits. Book 6, Rule 2 of the Rules Implementing the Labor Code states that the rule on retirement shall apply to all employees in the private sector, regardless of their position, designation, or status, and irrespective of the method by which their wages are paid, except to those specifically exempted. Part-time faculty members do not fall under the exemption. Based also on the retirement pay law and its implementing rules, part-time faculty members of private educational institutions are entitled to full retirement benefits even if these services are not continuous and even if their contracts have been renewed after their mandatory age of retirement. Alternative answers. Letter A. Under Article 302 of the Labor Code as amended by Republic Act No. 7641, part-timers are entitled to retirement benefits. De La Salle Araneta University versus Bernardo, GR number 190809, February 13, 2017. Another alternative answer, Narciso is not entitled to his retirement benefit anymore because of prescription. Money claims prescribes in 3 years under Article 306. Narciso's retirement claim accrued in 2005, the year he was considered retired by the school. He should have filed his claim in the year 2008. Letter B. If he is entitled to retirement benefits, how should retirement pay be computed in the absence of any contracts between him and Norte University providing for such benefits? Suggested answer. In the absence of any contract providing for higher retirement benefits, private educational institutions, including Norte University, are obligated to set aside funds for the retirement pay of all its part-time faculty members. A covered employee who retires pursuant to the retirement pay law shall be entitled to retirement pay equivalent to at least 1/2 month's salary for every year of service, a fraction of at least 6 months being considered as 1 whole year. 1/2 month salary shall mean 15 days plus 1/12 of the 13th month pay and the cash equivalent of not more than 5 days service incentive leaves. In total, this should amount to 22.5 days for every year of service. De La Salle Araneta University versus Bernardo, GR number 190809, February 13, 2017. Question. Nayon Federation issued a charter certificate creating a rank and file Human Employees Union. On the same day, New Human Employees Union filed a petition for certification election with the Department of Labor and Employment Regional Office attaching the appropriate charter certificate. The employer, Newman Corporation, filed a motion to dismiss the petition for lack of legal personality on the part of petitioner union. Should the motion be granted? Suggested answer. No. The motion should be denied. Under Article 240 of the Labor Code, a petition for certification election may be filed on the basis of a valid charter certificate issued to a charter local by a duly registered federation. Letter B. The employer likewise filed a petition for cancellation of union registration against Newman Employees Union, alleging that Nyon Federation already had a chartered local rank and file union, Newman Employees Union, pertaining to the same bargaining unit within the establishment. Should the petition for cancellation prosper? No. The existence of another chartered local chart under the same federation within the same bargaining unit is not among the grounds to cancel union registration under Article 247 of the Labor Code as amended by RA 9481. Alternative answer to letter B, petition for cancellation of union registration filed by employer Newman Corporation may prosper, while the employer may file a case as it is considered a party and interest in cancellation proceedings. Del Castillo, Asian Institute of Management versus Asian Institute of Management Faculty Association, GR number 207971, January 23, 2017. The union certification may be revoked or cancelled if it appears that there are sufficient grounds for its cancellation vis-a-vis fraud or misrepresentation in the election of officers, fraud or misrepresentation in the ratification of Constitution and bylaws. Question. Due to his employer's dire financial situation, Nicanor was prevailed upon by his employer to voluntarily resign. In exchange, he demanded payment of salary differentials, 13th-month pay, and financial assistance as promised by his employer. Management promised to pay him as soon as it is able to pay off all retrenched rank and file employees. 5 years later, and before management was able to pay Nicanor the amount promised to him, Nicanor died of a heart attack. His widow Nori filed a money claim against the company before the NLRC, including interest on the amount of the unpaid claim. She also claimed additional damages, arguing that the supposed resignation letter was obtained from her spouse through undue pressure and influence. The employer filed a motion to dismiss on the ground that A. The NLRC did not have jurisdiction over money claims, and letter B. The action has prescribed. Does the NLRC have jurisdiction to award money claims including interest on the unpaid claim? Suggested answer. The NLRC has jurisdiction over money claims arising from an employer-employee relationship where the amount claimed is excess of 5,000 pesos including interest, regardless of whether or not there is a claim for reinstatement. Section 10 RA 8042 as amended by RA 10022. Assuming that the NLRC has jurisdiction, has the action prescribed? Suggested answer. In Accessory Specialist Incorporated versus Alabama, GR number 168985, July 23, 2008, the Supreme Court held that the principle of promissory estoppel can apply as a recognized exception to the 3-year prescriptive period under Article 291, now 306 of the Labor Code. Nicanor relied on the promise of the employer that he would be paid as soon as the claims of retrenched employees were paid. If not for this promise, there would have been no reason why Nicanor would delay the filing of the complaint. Great injustice would be committed if the employee's claim were brushed aside on mere technicality, especially when it was the employer's action that prevented Nicanor from filing the claim against the required period. Alternative answer on letter B, yes, the action has unfortunately prescribed as there is only a 3-year prescriptive period for monetary claims under the Labor Code as in the case of retirement benefits. Letter C, may Nicanor's spouse successfully claim additional damages as a result of the alleged undue pressure and influence? Suggested answer. Nori failed to establish that Nicanor's consent was vitiated when he filed his resignation letter in BMG Record versus Aparicio, GR number 153290, September 5, 2007, the Supreme Court ruled that the matter of financial assistance was an act of generosity on the part of management. Under the circumstances, Nicanor had the intention to resign. Once management had accepted the resignation, Nicanor could not unilaterally withdraw this voluntary act of termination of employment. Alternative answer. Letter C. No, in this case, Nicanor voluntarily resigned. Burden of proof of the fact of dismissal and of the alleged undue pressure and influence is upon Nicanor's wife as claimant. Absent such proof, the claim of damages must fail. Question. Natasha Shoe Company adopted an organizational streamlining program that resulted in the retrenchment of 550 employees in its main plant. After having been paid their separation benefits, the retrenched workers demanded payment of retirement benefits under a CBA between their union and management. Natasha Shoe Company denied the workers' demand. Letter A. What is the most procedurally peaceful means to resolve this dispute? Suggested answer. The parties may resolve this through plant-level mechanisms such as a labor management committee or a grievance machinery under a collective bargaining agreement. Letter B. Can the workers claim both separation pay and retirement benefits? Suggested answer. In Santos versus Senior Philippines, GR number 166377, November 28, 2008, the Supreme Court held that retirement benefits and separation pay are not mutually exclusive, and both benefits may be paid in the absence of a contrary stipulation in the retirement plan and or in the CBA. Alternative answer. Yes, in the absence of any express or implied prohibition against it, collection of both retirement benefits and separation pay upon severance from employment is allowed. This is grounded on the social justice policy that doubts should always be resolved in favor of labor. Goodyear Philippines Inc. versus Angus, GR number 18549, November 12, 2014. Question. Nilda worked as a chambermaid in Hotel Neverland with a basic wage of 560 pesos for an 8-hour workday. On Good Friday, she worked for 1 hour from 10 p.m. to 11 p.m. Her employer paid her only 480 pesos for each 8-hour workday and 70 pesos for the work done on Good Friday. She sued for underpayment of wages and non-payment of holiday pay and night shift differential pay for working on a Good Friday. Hotel Neverland denied the alleged underpayment and arguing that based on long-standing unwritten tradition, food and lodging costs were partially shouldered by the employer and partially paid for by the employee through salary deduction. According to the employer, such valid deduction caused the payment of Nelda's wage to be below the prescribed minimum. The hotel claimed that she was not entitled to holiday pay and night shift differential pay because hotel workers have to work on holidays and may be assigned to work at night. Question. Does the hotel have valid legal grounds to deduct food and lodging costs from Nilda's basic salary? Suggested answer. In Mabesa versus NLRC 271 Iskra 670 1997, the Supreme Court established 3 requirements before the value of facilities such as food and lodging may be deducted from an employee's wages. First, proof must be shown that such facilities are customarily furnished by the trade. Second, the provision of deductible facilities must be voluntarily accepted in writing by the employee. And finally, facilities must be charged at fair and reasonable value. In the case at hand, the second and third requisites on voluntary acceptance of deductible facilities in writing at fair and reasonable value was not established. Alternative answer. No, in Atok Big Wedge Association versus Atok Big Wedge Company, GR number L-7349, July 19, 1955, the Supreme Court distinguished facilities from supplement. Supplements constitute extra remuneration given to laborers above their wage. Facilities are items of expense necessary for the laborers and his family's existence and subsistence. Boards and lodging are treated as supplement if the company benefits from the employees not going home anymore or not leaving his workstation. Since Nilda is a chambermaid, her board and lodging should be treated as a supplement. Letter B. Applying labor standards law, how much should Nilda be paid for work done on Good Friday? Show the computation in your test booklet and insert your final answer. As an employee paid 70 pesos an hour, Nilda was entitled to an additional 100% of her hourly wage for working on a Good Friday, plus 10% for night differential pay. Nilda should be paid a total of 154 pesos for working that day. Question. A certification election was conducted in Nation Manufacturing Corporation whereby 55% of eligible voters in the bargaining unit cast their votes. The results were as follows. Union Nana 45 votes, Union Nada 40 votes, Union Nara 30 votes, No Union 80 votes. Union Nana moved to be declared as the winner of the certification election. Can Union Nana be declared as the winner? Suggested answer. Union Nana cannot be immediately declared as the winner. A runoff election pursuant to Article 268 of the Labor Code must be first conducted. A runoff election is required since the present case involved an election which provided for 3 or more choices, with no choice receiving a majority of the valid votes cast and the total number of votes cast for all contending unions being at least 50% of the number of votes cast. Letter B. Assume that the eligibility of 30 voters was challenged during the pre-election conference. The ballots of the 30 challenged voters were placed inside an envelope sealed by the Dolly election officer. Considering this said envelope remains sealed, what should be the next course of action with respect to the said challenged votes? Suggested answer. Since the challenged votes may materially affect the results of the election and may in fact even give Union Nada or Union Nara an absolute majority, then the said challenged votes should be opened. Pursuant to Rule 9, Section 11 of the Rules implementing Book 5 of the Labor Code, the envelope with the challenged vote shall be opened and the question of eligibility shall be passed upon by the Dolly mid-arbiter. Question. NICO is a medical representative engaged in the promotion of pharmaceutical products and medical services for Northern Pharmaceuticals Incorporated. He regularly visits physicians' clinics to inform them of the chemical composition and benefits of his employer's products. At the end of every day, he receives a basic wage of 700 pesos plus 150 pesos productivity allowance. For purposes of computing NICO's 13th-month pay, should the daily productivity allowance be included? Suggested answer. No. The second paragraph of Section 5A of the revised guidelines implementing the 13th-month pay law states that employees who are paid a fixed or guaranteed wage plus commission are also entitled to the mandated 13th-month pay based on their total earnings during the calendar year on both their fixed or guaranteed wage and commission. However, the Supreme Court in Philippine Duplicators Incorporated versus NLRC 241 Iskra 380 GR number 110068 February 15, 1995 declared the aforesaid provision as null and void with respect to those medical representatives who do not obtain productivity allowances by virtue of generated sales. Such allowances are in the nature of profit-sharing bonuses or commissions that should be properly excluded from the ambit of the term basic salary for purposes of computing 13th month pay due to employees.